what attracted you to law?
Ooh, I don't know. So I guess from 0 to 10 or 2 to 10 or whatever, I always thought I was going to be a doctor. And then somewhere, it must have been a TV show, and dare I say Perry Mason or something, but like at age 10-ish, it's like, oh, I think I want to be a lawyer. And I tend to talk a lot, and I've been told I have a bit of a big mouth. And so many people in my life have said, oh, you'll make a great lawyer. And so I just kind of followed that path all the way through college and, ultimately law school. Kind of just thought that was where I was going to end up and head.
Interesting.
Yeah.
So if you're just joining us, we're here with Brad Malicki from Holleran & Sage. He's a merger and acquisition attorney. And we're just going to talk for a little bit about why a merger and acquisition attorney and what they do and how they do it and why you need one and when you need one.
Yeah.
Thank you for joining me, Brad.
Thank you for having me.
And so you decided you were going to be an attorney. You headed this way. There's a million different options, right?
Sure.
So why mergers and acquisitions?
I think a lot of it is unlike doctors, I think. So I think a lot of like the medical profession, I think most students will go to medical school. And then my understanding anyways, they place into a particular area, be it orthopedics or pediatric or what have you. It isn't necessarily the same in the law. And so I think a lot of it has to do with, like, we don't have a hospital to train at or anything like doctors do. So a lot of it is just where you end up with your first job. And,
Okay.
Sometimes lawyers will, they're hard fast. I want to be a tax lawyer. And so you do everything you can to find a firm that deals with taxes or mergers and acquisitions or what have you. And sometimes lawyers, young lawyers are able to do it. I think certainly much more now than 25, 30 years ago when I got out. But quite frankly, most of us, when we're young lawyers, we're poor. We've been to school for 8 years. We need a job. And so
Fair.
you get a job, and whatever that firm happens to be doing or happens to need you for, I think that's kind of where a lot of lawyers end up getting placed, or that's how a lot of lawyers find their path. And so I went to work at a law firm when I first got out of law school, and it did a lot of transactional work. It was kind of a general practice firm, but it was more focused on transactional work. And I think that's just kind of what sent me down that path. And then as I continued down the path and you gain more and more experience doing that kind of stuff, you kind of end up in a world dealing with people who are doing transactional based work, mergers and acquisitions and corporate type work. And, 20 years later or 25 years later, you wake up and you're a mergers and acquisitions attorney as opposed to, tax attorney or litigation attorney or what have you. So I think that's mostly how I ended up here.
Okay. Excellent. So what keeps you here? I mean, you could pivot, right?
Sure. I enjoy the work. And I think to a certain extent, just, I'm laying out a path that isn't necessarily hard and fast, but I think if I didn't like the work, I would go do something else. Certainly I would pivot, but I enjoy what I do. I enjoy the deals and getting involved in the deals, and kind of at the end of the day, I think one of the things that's most intriguing or most beneficial is that we always are essentially negotiating to yes, right? Both sides want to get to the yes point. We want to close the deal. You're not going to sacrifice your client's best interest or anything, but at the end of the day, you're trying to do good by your client and reach the ultimate goal, which is the deal, the closing of the deal. Everyone else at the table, regardless of how many people are involved, should be at least aiming for that same goal. And I like that. I mean, I like to consider myself a good human being. I like to do good for others. And so I think it fits my personality. Okay. Litigation, much more adversarial, and usually there's a winner and a loser. Typically, not everyone wins as much as they hope they won. And usually, thankfully, people don't necessarily lose as much as they thought they were going to lose. But there's usually a winner and a loser, usually. In transactional stuff and M&A work, if it's done right, or at least if it's done the way it was intended when the letter of intent was first issued, kind of everybody's a winner. And that's a nice part of the area of law that I'm in.
That makes sense.
Yeah.
That makes sense. That's kind of what I like about it too. You're working for the client, but at the end of the day, everybody should leave the table a little happy and a little unhappy.
Right.
Because you're not going to get everything you want. But you need to get the important things.
And the ultimate goal, right?
Yeah.
Which is if you have a buyer and a seller, or a merger and a mergee, both of them want to do it.
Right.
So they're not going to get everything they want. But if it actually happens, then, usually they're both pretty happy. And that's not a bad way to go through life,
That's true.
Yeah.
That's true. Good outlook. When we sit down at a table, we want to sit down with the right team. So kind of let's start there. We always recommend a skilled, experienced M&A attorney, not a litigator, to come in and negotiate this contract. So I know why I think that's important, because I think it gets us to that yes with people that know how things work. Why is that important in your mind?
Well, I think it's no different than anything else in what you do in the world, right? So if you want your car fixed, you don't call your electrician, right? You go to your auto mechanic.
Mm-hmm.
And I think in our world, if you want the deal to go smoothly or as smooth as it could, and you want to get to that yes, you want to get to that close, you need somebody who knows how to do it and who's been doing it. And typically, I'm not picking on litigators if there's any litigators watching, but typically litigators they're not trained to do that. They're not experienced in doing it. And so it's all new terrain to them. And I think that holds true with a lot of different type of lawyers. And in some regards, even general practice lawyers. There are still a good amount of lawyers out there that are general practitioners, which means they do a little bit of everything.
Mm-hmm.
And are they able to do it? Sure. Are they licensed to do it? Sure. But are they necessarily the best pick to do it? Probably not. And
what are some reasons they're not the best pick?
I think a lot of it's experience and familiarity. So if you're not doing that type of work, number one, you don't know what you don't know.
Mm-hmm.
And number two, you don't know what the norms are. So if somebody comes to a table and offers up a particular term or a particular provision, and if you're not familiar with it, or if you haven't seen it before, you don't know how often it's been used or is being used, you may object to it, and you may be objecting to it unreasonably. And you don't mean to be unreasonable, but you don't know any better. You don't know what you don't know. And so I think that's one of the big reasons in using people who are experienced in their area, be it law or anything, that's you want to use those type of folks because they're going to be the best people to advise you and say, hey, look, I know you really want this particular term, but it's really unreasonable for this particular situation or for this particular deal or this particular climate. Or you should be asking for more. You're giving away the farm. It's not fair. It's not reasonable. You should be giving. It's big with lawyers. We love reasonable, but it's not reasonable. It's not fair. And so, you could advise your client that way. But if you haven't done an M&A deal ever, or not in 6 years or 8 years, things change. Climates change.
Mm-hmm.
Sometimes it's a buyer's market. Sometimes it's a seller's market. Sometimes there's cash available. Sometimes there's not. And that could all control or direct the way a deal should be structured or should end up.
What do you see the attorney's role in a negotiation?
That's a tough question.
It is a tough question.
Yeah, that's
Sorry.
a tough question. No, it's okay. I was hoping for an easy one, like what's my favorite color? But no, I'm just
no.
So I think it could be crucial. And then sometimes I think, honestly, again, some of my colleagues are probably going to hang me, but I think sometimes lawyers can over-lawyer things and over-negotiate things. It's in our personality. Lawyers are competitive by nature, at least in my experience anyways. Lawyers are competitive by nature.
Mm-hmm.
And sometimes I think we could lose sight of the end goal by over-lawyering or by over-negotiating.
What does over-lawyering look like?
So if you can accomplish, I'm trying to think of a good analogy and I'm failing, but if you can accomplish something with a sentence, right, and you let two lawyers have their way, it may end up being a book. And
at least a page.
Right, or at least a page, for sure. I'm exaggerating with a book, but certainly at least a page. And sometimes that's necessary, right? I have clients all the time who, will tease me a bit and say, do we really need this? This isn't important. And at the end of the day, and I've said this forever, at the end of the day, none of the paper is important if you have two people who can shake a hand and make a deal and understand all of the terms and ramifications of the deal. And I know people who actually have done deals that way. Mm-hmm. But that's very, very infrequent, right? And usually those stories end up in horror and drama. And not because they're bad people necessarily involved in the deal, but because people understand what they want to understand. People hear what they want to hear. People have different perspectives as to what they heard and what they said. Mm-hmm. And so that's the reason why we have paper, right? That's the reason why we write things down. And that's why we go back and forth and let everyone review it and kind of digest it, make sure it's what they wanted. I think going back to the one sentence versus one page, sometimes you need a page to make sure that everything's covered, all points are met. But sometimes you'll have lawyers that will overwrite, over negotiate, and that honestly can hinder the deal. And so when you're saying how important is a lawyer's role in negotiation, I think it could be crucial and vital. And at times, being 100% honest, I think it could be problematic. Sometimes I think allowing M&A advisors or allowing even the parties in some limited situations to have some conversations amongst themselves, it's not the worst thing in the world, and kind of keep the lawyers out of it a little bit, because sometimes when you bring the lawyers in, it adds a level of, I don't want to say animosity, but it just adds a level of back and forth that isn't always necessary per se.
So sometimes it feels like, and this is from a non-attorney, that the attorney's job is finding the worst case scenario and writing the language for that particular instance. And ultimately, as an advisor, I hope that that contract goes in a folder and goes in the drawer and nobody looks at it again.
Home run.
Right?
That's the home run.
Because then we have a buyer and a seller that never had to fight about anything.
Right.
That's not always the case. So I found the one we worked on that we had some extra piece after the deal closed. There was some contention over working capital, and we literally had to dig back into the contract and see exactly how things were spelled out. Which way do you see things more often?
With regard to post-closing issues or detailed SPAs or your purchase and sale agreements?
Detailed purchase and sale agreements all the time.
Sure.
Where the contract's not put in the drawer.
Oh, yeah. Unfortunately, quite often. However, though, having said that, I'm not saying that it ends up, I think if I'm recalling the situation that I think you're recalling, that was a little bit more intense than many.
Than normal.
A lot of times it's pulling it out of the drawer, blowing the dust off and saying, oh, remember paragraph 19, subsection 231? We addressed this and you agreed to this. And, and that oftentimes will put it to rest, or it'll just be a small exercise in putting it to rest. And part of the reason why we make them so detailed is so we can try to cover everything. And there is no room for interpretation 6 months later, a year later, and so forth. But I do see a fair amount of people coming back, especially in the first year, first 18 months, questioning. Something came up. Yeah. This isn't, I didn't know this. Do I really have to pay for this? Was that my responsibility? I see that a fair amount. I see it a fair amount.
Okay. We used it in one deal, and I don't think this was with you, so apologies. We saw one deal where the only time we looked at the contract afterwards was to remember how many days we had to respond to different things.
Sure.
True up time happens. It's tax season. The accountant needs 60 days instead of 45 days to look at this. We agreed to 45. It's tax season. Can you give us to 60? Sure. So that, that's not a hard look back.
No. And I see those as well. Like, not every time we're doing a look back is there a monumental issue.
Right.
But a lot of times we'll pull it out, and kind of like the example I had said, we did talk about that. Remember this? We talked about it. And sometimes they remember talking about it and agreeing to it. Sometimes they don't. We have to dig a little deeper. But when I'm saying oftentimes people come back and look at the agreement, it doesn't necessarily lead to a problem or an in-depth dig like we had in that particular circumstance. But I think oftentimes we'll look back at it just for timing, responsibility, obligation, and so forth. And I think if you have a properly drafted agreement, that helps, because all parties can see what everybody agreed to, and it's in writing, and there's no question about it.
And they all signed it.
Right. And theoretically read it and understood it, And so I think that's important. I think it's important to have a properly detailed, not necessarily over-lawyered, but certainly an under-lawyered agreement.
Right. Well, and the one of the things that surprised me as we started working through, several things surprised me when I started working through agreements with people. The length I always warn my owners, this may be the longest legal document that you have participated in. for a majority of business owners, a purchase agreement on a business, it's the most lawyering they're going to see. And it's written in legalese. So one of the things that came up during a negotiation is the attorney said, do we want to remain intentionally silent? And my question was, pardon? I don't, why would we remain intentionally silent? And, you know, in that particular instance, we actually did. It was something that could go either way. And circumstance at the time of conversation would be more important than could lead to over lawyering.
Makes sense.
So what other techniques or skills should we be kind of on the lookout for in negotiating, working with the attorneys?
Well, just specifically working with the attorneys, don't let them talk too much. As we're doing now, I think I'm talking more than you are. So.
Hours, yep.
Yeah, and I mean, lawyers do need to obviously make billable hours, but a good lawyer, honestly, Deborah, a good lawyer is not going to just ring the clock, right? Good lawyers have plenty of work to do. And so they shouldn't need to sit and take one matter and just for no good reason. Does it happen? I'm sure. You know what I mean? And I'm sure there's plenty of circumstances and plenty of firms where it happens. But generally speaking, most lawyers who have plenty of work to do, and if they have plenty of work to do, that's a good indication that they are a good lawyer. Mm-hmm. They don't need to ring up a bell on any one particular client. They do want to make sure that they're doing their job for their client, right? That's first and foremost. They've got to make sure that they're properly representing the client. It's in our rules of practice. It's part of our ethics code. Practically speaking, they also want to try to make sure they don't get sued, because if something does go wrong, it's usually not the accountant or
the attorney gets sued or the owner gets sued.
Both. So in looking out for our client's best interest, we certainly don't want them to get sued. Mm-hmm. But taking it selfishly a look at it, we also don't want to get sued. So if something does go wrong, kind of especially, at least in my humble opinion, the way the world is now, no one takes any personal responsibility for anything anymore. And so we are sometimes ultra careful just to make sure that the client understands what they're signing. They have no questions, especially with regard to the representations and warranty sections and the covenant sections. I try to go over them thoroughly with the clients. I try to document it thoroughly with the clients. Do you have questions? Do you understand?
Can you give us a quick definition on that?
Sure. So representations and warranties in a deal are things that each side, buyer and seller, are promising to the other. They're promising that they're a properly formed entity. They're promising that they've paid all their taxes in due course. They're promising that they have authority to enter into the agreement. And there's any number of representations and warranties in a deal. It could be as many as 25, 30 different representations and warranties. From a seller perspective, they're giving these representations and warranties, these statements to the buyer. And the buyer, in part, is relying on these statements and saying, oh, okay, I'm going to buy your business. I'm going to buy your assets because you're telling me you can sell them to me. You're telling me that they work. You're telling me that they don't have liens on them. Mm-hmm. And if any of those things become untrue, then that's what would give rise to the other party being able to come back and look for recourse. Mm-hmm. You told me you own these 50 machines. You don't. Your brother-in-law owns 10 of them. They're really his. He came to pick them up. I'm 10 machines shy now, and I paid you $10 million. I should get some money back.
Yeah, kind of a problem.
Kind of a problem. Certainly for the buyer, not so much for the seller, but certainly for the buyer. And so a very drastic example, obviously. Correct. It doesn't happen often, but you know, it could, I guess, theoretically. But so those kind of things are what we want to make sure that the client understands thoroughly, and make sure that if they're making that representation, they understand it so they can actually tell us if it's true or not. Because nobody knows, as you know, nobody knows their business better than they do.
Right.
So as an outsider, some clients we've represented for decades, and we do have a little more familiarity. But sometimes they're a first-time client. We don't know anything about their business. We don't know anything about their structure, about their history. Mm-hmm. All we know is what they've told us. And so, again, kind of going back to a phrase that I use more and more often these days, is not knowing what you don't know. If I'm not properly asking questions to get the right information, he doesn't know what he should be telling me in many instances. Right. He doesn't do this for a living. Right. He's a machinist or an electrician or what have you. And so if I'm not eliciting from him the information that we really need to be able to put this together, shame on me. And
Yeah.
so that's why we try to be as careful as we can. And quite frankly, shame on me if I don't do it, then it does open me up
It
potentially
does, yeah.
to a lawsuit.
So schedules fall into that category of compiling everything. And it sounds like such an easy word, right? Like we think of a schedule in generic terms as just writing down where we're going to be tomorrow. But scheduling out a business is scheduling everything for the business and every exception to that reps and warranty.
Sure.
And so if there's a rep that they can't make, then we have to put it on a schedule. We have to list it out and say, so it doesn't, sometimes the reps and warranties feel punitive. And so I think it's important to make sure that our owners know just because everything isn't perfect in your business, it's not that we have to hide that it's not perfect. We actually need to tell them what isn't perfect. I can agree to X, Y, Z, A through Z on, yes, I agree to everything except for C. At C, there was this one time this person fell in my business and they sued me and I had to pay them.
Sure.
And I think that's kind of where sometimes they get stuck
Mhm.
on wanting to talk out things that have happened in the business. It's actually more important that they tell you. And we all watch TV. Most people watch TV or read. We're exposed to social media. We understand that there's a confidentiality expected with your attorney.
Sure.
Talk about that and how kind of it impacts a deal where not only do you represent them, but they're working with me and they're working with their accountant and they're working, with all these different parties. How does that interplay in your confidentiality issues?
It could often be, honestly, very, very complicated. Because in addition to confidentiality, we have a bunch of other rules that most other humans don't need to live by, which is honesty and ethical obligations to fellow counsel. And in the business world, not that I'm causing problems with any of my business friend folks, but they don't have quite as many rules as we do oftentimes. So, a business guy can hold up a white piece of paper and say it's black, and there's nothing wrong with that.
Mhm.
Lawyers, by our rules, can't. We're not supposed to intentionally do those kind of misleading things. But that can cause a problem sometimes, because sometimes we have a client that says, hey, let me tell you something, don't tell anybody though, which is the worst words we ever want to hear, but we can't once they tell us that, and that could be a problem, right? So I'm going to make a very, very obscure example, but it could be very real. We have a husband and wife that owns a business. We're going through our representations and warranties. One of those representations commonly is, have you had any employment concerns? Have you had any employment issues that you either know of or are expecting?
Right.
So, have you fired somebody wrongly or wrongful termination? That would be something that would have happened and you know of, or something that hasn't come to light yet, but is lingering out there, maybe a threatened claim. Threatened claim is that one of the employees was having an inappropriate relationship with the owner, with the husband owner. Okay. And that inappropriate relationship was spurned on by the husband owner. Female employee,
Problem.
right, says, hey, guess what? You shouldn't have done that. I don't like that you did that. And I'm going to start telling people, unless wife doesn't obviously know about the problem. And now we're doing this reps and warranties and the schedules. And here comes the promise you won't tell anybody. So it could be extremely difficult. And in that instance, I can't pick up the phone and say, hey, Deborah, how do you feel about this? Did you see this on a deal recently? How have you dealt with this in the past? Very, very difficult situation to kind of overcome. And it's trying, at least in my opinion. It's trying. It makes my job. It's one of the hardest things I think I deal with. And I think all lawyers, you go home at night and my conversation about how my day was at work was, it was a day. I mean, I don't say anything to my wife because I don't want to breach any confidentiality. So I just say nothing. And I think, and that's an extreme example too, by the way, Deborah.
Right.
It doesn't happen every day.
No.
When it does happen, things like that happen, it makes it extremely challenging to both continue to represent the person, especially if something that person did was morally questionable. It makes it extremely difficult to represent he or she, but it also makes it difficult from a greater, broader deal perspective.
Right.
I can't tell the accountant. I can't tell you. I can't tell, everyone else involved in the transaction. When we haven't talked about it yet, I don't know if we're going to, but sometimes in a deal, you'll build out a reserve or an escrow for potential liabilities or potential things that go wrong that a buyer may come back at the seller for. I can't say, hey, Mrs. Smith, you might want to put a couple of mil in the bank there, So it's challenging, or could be challenging. Yeah. That's for sure.
Yeah. Yeah. We like the phrase "go ugly early."
Yes.
And we work with our clients to do that open communication. But certainly there are instances where circumstances make it so that
the ugly's hidden. Right?
Yeah. Don't love working to sell businesses in a divorce. That's an awkward one. But it's doable.
Sure. And necessary.
Yeah.
Honestly, quite frank.
Absolutely.
Sure.
Absolutely. So we didn't quite make it to escrows. That's a level of complexity. There's so many options to cover. Just for those of you that are listening that don't know, it's not unusual for this to be a 60-page document with a couple other extra 30-page documents on the side.
Just for good measure.
Right. Well, I mean, if you're selling a building, leasing a building, have an owner's note, have rollover equity, have shareholders agreements, have employment agreements, like how many? I've never asked this question. How many pages do you typically draft to get through a transaction on average?
Hundreds. I mean, the purchase and sale agreement and the schedules alone are
right.
north of 100 almost every time. And then, as you alluded to some of them, consulting agreements, employment agreements, non-compete agreements, non-solicitation agreement. I mean, the list goes on. And if each one of those are only 10, 15 pages each, I mean, there's another 100, 150 pages. Yeah. So it's hundreds.
Yeah. I know when we get a closing document, it's in a zipped folder.
Yep.
Digitally, right? Like it's not emailable at that point.
So when I'm still slightly old-fashioned. I still am a fan of paper. Mm-hmm. And so at the end of a closing, we'll typically make a closing binder for our client. And so we make a table of contents with all the documents that are contained in the deal. We tabulate it, and so it's easy to find. Mm-hmm. And again, hopefully they put it in a drawer on a bookcase and don't ever need it, but it's there if they do. But oftentimes the binders will be multiple, and the binders are several inches each. So I mean, I don't know how many pages are in there, right? But I mean, a ream of paper is about, I think, 250 pages, something like that. And this is several reams typically. So it's a lot of paper.
A lot of reading.
Yep.
A lot of reading.
A lot of reading indeed. a lot of periods, a lot of commas.
Yes, most definitely. I don't love it when we're sitting in a meeting and the attorneys are like, well, this sentence is drafted differently than I would have drafted it. And sometimes we have to be. But does it mean the same thing? Say, because yes, I would write it differently. I promise. Right. And about half the words.
I won't take any offense to that, by the way.
But we do work with our clients to translate a lot of this so that they have an extra set of ears that's used to hearing these terms.
Sure. And we greatly appreciate that.
Probably,
for real,
yes.
We do.
Yeah. I could see that it would be difficult otherwise. I think that there would be more billable hours spent without somebody like me there.
To kind of parse through it.
Yeah,
sure.
Absolutely. So as we're wrapping up, kind of our ending question is, if you were not sitting there writing reams of paper for transactions and reviewing them, what else would you do?
Plumber. I'd be a plumber.
That was so fast.
Mm-hmm.
That was so fast. So why?
And so let me preface this also by saying I've never been a plumber. So if I became a plumber, I might quickly say, gee, do I wish I was a lawyer again? I mean, That's very possible. But I have been an electrician, not licensed. But my brother-in-law was an electrical contractor. So when I was in college and law school, and even now, quite frankly, he'll call me and say, what are you doing Saturday morning? Do you want to go for coffee? And, oh, by the way, bring your tool belt. So that still happens occasionally, right? For coffee. Really? What are we working outside or inside? Well, so.
After training.
Right. So I do have experience being an electrical helper. I was never licensed. So I can't say I was an electrician. But I don't think I'd ever want to do that for a living. But plumbing always fascinated me. And one of the things that I think was beneficial for a plumber over an electrician is you have a bad day as an electrician, you die. You have a bad day as a plumber, you get wet. And so
Okay.
maybe a little dirty, but that's the worst.
Yeah.
There are, a lot of other practical reasons, which I won't bore you guys too much with, but if you're wiring a house, electricians are in every wall and every ceiling, right? There's wire in every wall and every ceiling in your house,
Yeah,
basically.
absolutely.
Plumbers, typically, most houses, they stack it. It's a bathroom,
Oh.
kitchen off to the side, and that's it.
I never really thought about where there was plumbing. I'm not going to lie.
Not the worst way in the world. There are so few of them now, Deborah. I mean, you can't find one. And
Right.
so they are the ones that are capitalizing on it anyways. They make a fortune, quite honestly. And it's
Yeah.
not like it was 100 years ago where you're carrying cast iron tubs up 3 flights of stairs. I mean,
No.
everything's plastic. The pipes are plastic. You don't
Yeah.
solder pipes anymore. Soldering is when you
Oh, yeah. No, I know what soldering
Okay.
is.
I didn't notice you, but for the benefit of your viewers or listeners, right?
Fair.
They don't do much of that anymore. It's it's not the worst way in the world to make a living, in my opinion. So
Excellent.
Yeah.
Well, that's now you have me thinking about where the plumbing is in all the walls. But that's interesting. Fun fact, just to segue into bizarreness.
okay,
Working with a client that has an entity in China.
okay,
When you buy property in China, the plumbing, the electricity, everything is taken out of the building. You have 4 exterior walls when you buy a building.
really?
That is all you're buying.
Wow,
And you come in and you fit it out however you see fit, but you buy the exterior walls only.
really?
Yeah.
That's interesting. Holy cow! Which meaning, obviously, they're tearing all the interior down, whatever wall
Yeah.
coverings they use.
Yeah.
Wow, huh? Very fascinating.
It's like,
Huh.
and this is why I like this job, because
Yeah.
you never know what you're going to learn.
No, that's a great little tidbit of information.
Yeah.
Does that apply for residential people as well, like folks who buy a house?
You
or
know,
is it just
I don't know.
strictly-
I know commercial.
Okay.
So I don't know about housing. Now you're going to make me go ask that. by
Yeah,
the
because
way.
I'm curious.
Now I'm curious.
Yeah, like that's.
Um,
Can you imagine showing up to a house with your spouse, some kids, and there's no plumbing? There's no
walls.
Oh, there's 4 exterior walls. Yay!
But honestly, thinking about it from a housing perspective, it's a chance to revamp the house however you want it
Yeah.
all the time.
Yeah, absolutely.
But
Huh.
yeah, their plumbers must make a fortune.
I would think so.
Think about how many times you need a plumber.
And replumb the same space, Very interesting. Well, thank you for sharing that with me.
You're
very,
welcome.
very interesting.
Well, Brad, thank you for joining us. And we'll have your contact information below if anybody needs M&A attorney, if they need corporate advising as well. That's something that you do too, correct?
Yes, indeed. Absolutely. Well,
Excellent.
thank you for having me.
You're welcome.